Most people think about probate or estate planning kind of depends on the asset itself, but that's usually not true. And so in this video today, I am joined by Emily Nestor, a probate and estate planning attorney, to explain how ownership, titling, assets, and debt can all sort of affect estate plans and probate. I'm Alex Craig, a real estate agent specializing helping people in estate transitions. So I thought it would be great to kind of start with our scope and guardrails and sort of this disclaimer here. So I wanted to kind of start off with the question of, how do you approach public education without crossing into the legal advice, and kind of how people should be taking this information, if they're trying to apply it and that sort of thing.
Yeah, absolutely. I think that's a great start to kick us off here. So when I'm, giving education, it is hard in my world because estate planning and probate is so fact dependent on a particular estate, and what one asset looks like to another may be completely different in somebody else's estate pattern. So it's really hard to kind of categorize and give broad information. So I try to focus more on how assets are handled under that specific estate and what may trigger. As again, working with a legal professional is going to really help in this scenario because again, it's so fact specific. That trying to educate as a general whole is complicated because you do potentially cross into that line of giving legal advice. If somebody watches my video and says, well, Emily said that house is not a probate asset, but why is it on mine? Could it be legal advice? So you kind of have to watch what you say. In our world, we have legal ethics where we can't just advise people who aren't our clients. So we do have to keep it pretty general. But again, especially because it's so fact specific, it is good to keep it general anyway, unless you are working with that specific individual.
Yeah, absolutely. I think so kind of the way I hear it, I guess, is that if somebody's watching this, is to make sure that even when we're talking, and even if we're talking at a high level, that even if some of the information that we're sharing matches your situation, it may not be the advice that you should be acting on, and it should not be construed as legal advice.
Absolutely, for sure. It could be
So,
similar, but one little thing could
yeah.
trigger it to be completely different. You wouldn't know.
Absolutely. So, with that said, let's dive into kind of some of these high level conceptual things that at least give people maybe a framework to operate within and how to think. And so, that first question is kind of how can we conceptually distinguish between probate and non probate assets?
Yeah, so right off of the bat, there isn't just a general definition. I mean, if you really want to break it down, an asset that has to go through probate's a probate asset. But nonetheless, it doesn't qualify just because you have a house, it's a probate asset. Where it really comes down to the distinction is going to be how the asset is titled, and how it's owned, and if there's a beneficiary designation. So if a decedent passes away and that specific asset, here let's talk about a bank account, if that bank account is solely in the decedent's name, nobody else is on the account, there's no beneficiary, depending on the value of that account, we're looking at probate. However, on the other hand, if you have somebody with a beneficiary designation for their bank account, it's potentially a not probate asset. So that's just an example of how dependent on that ownership titling or beneficiary designation is what qualifies those probate and not probate assets. Probate's more of a vehicle used to allow or to verify who has the authority to handle a decedent's assets, right? Because if you pass away with nobody other than the decedent, how is a bank to know, okay, yep, Alex can handle this account? If you just show up, you could be anybody's brother, mother, or son, cousin, anybody could try and to say that. And of course, you're going to be entitled if you show up to the bank account or to the bank to ask for that account. So it's more about using the probate court when there is that discrepancy of, okay, this asset only has the deceased person's name on it. Who's supposed to do what with it? Probate's used to say, okay, this person has the authority And then these people are who inherits that estate, divided however that may look like per a specific estate again. But that's what we use the probate court for. So if you think about that concept, okay, if it's used for verification of how or who handles the estate and who gets the estate, how would we get into that situation? Well, when that particular asset doesn't have anybody listed or doesn't have a beneficiary, it's kind of when we're in limbo of an asset of yeah, is it annoying we have to go to court? Sure. But on the other hand, if it were you in that scenario, would you want the bank to hand out your bank account to Joe Schmo without any sort of verification? Now, if there's a beneficiary designation, the bank has their own process for what that verification look like. And that would be where you keep it out of probate is if your bank account had a person listed to inherit if you pass away, that person goes to the bank, they do what the bank needs them to do, and then they can get a check that way. So it really just the totality of distinguishing probate versus not probate is more of how is the asset titled? Is there a beneficiary? And where do we go from there?
Yeah, that makes sense. I do like what you said about probate being like a vehicle because I do think obviously probate gets a negative rap. Obviously, I think part of it's probably just because it comes in at a time of emotional grief, and
Yeah.
but also then there's this like it's slowing us down kind of process, and people just want to get through it sometimes, and so I think, but like you said, it's really there for protection. I mean, just for all parties involved, obviously the decedent as well as any creditors or anything like that that may still, that may have a claim to any of the assets in the estate. This video was born out of the desire for executives to be able to classify assets and debts quickly. And why do you think executors sort of feel that pressure to categorize assets too early?
I mean, there could be a number of reasons. I think the one that I see the most is pressure from somebody who feels entitled to receive the estate, or think that they're entitled to some particular asset, whatever that may be, whatever the reason may be. They then put some pressure on the person in charge to get it figured out. I see that probably more often when somebody comes in feeling rushed and pressured. I think it could also have to do with how that particular person is and how they function as a person, and or how grief factors in. Sometimes people to avoid or process grief need to keep moving and keep going and not let it sit. So if that's their type of MO, then they are jumping in, but then that grief with everyday life, adding those executor tasks in, you're adding that extra pressure that way. But I think again, the biggest way to avoid that is to meet with an attorney right out of the gate, regardless of if you're going to work with that attorney or not. I always recommend that you do. But even if it's, you meet with me and for whatever reason you don't choose to work with me, but you work with someone else, at least meet with someone to start. Because one of the first things I tell people is let's slow down for a minute. You just lost somebody. There isn't necessarily a time frame, but you also can't just let it sit either. But that's what we're here for, to help you work through that time frame. If you start getting pressured by someone, that doesn't mean automatically you have to do something depending on the circumstances. It's if it's been 2 years and then you're getting pressured, you probably got to do something, So there's some circumstances that do justify, a push. But a lot of times it's just people don't know. And so that's why meet with an attorney, even if it's just one meeting in the beginning, to kind of get some of those jitters out, get some of that pressure reduced so that you can have a clear head to start the process rather than starting, get flustered, and then just trying to spiral or get out of your spiral at that point. Because when you meet with someone mid process, it's a whole lot harder to figure out what in the world's going on than kind of starting the process with them and working them through it.
Yeah. Yeah, I like that nugget of kind of pausing and slowing down is something I've been mulling over probably the last actually 30 days because I've been thinking about sort of like pausing because there's that tendency to create action, and if we can almost like think about it as we can create action but we have to make sure the action is not irreversible or material in nature. Like, for
Absolutely.
example, obviously acting without authority or something like that.
Yeah.
But we can do things like, documenting belongings or starting to collect some of the paperwork, which is action, but it's not anything that's going to be problematic where, it's essentially buying us time to create space for judgment so we can learn or consult with an attorney or a professional to get better judgment on actually how we should be moving through this. So I've been mulling over that idea for the last 30 days. But so I kind of wanted to talk, we kind of talked a little bit about titling, and I think I wanted to dive into maybe some of the mistakes. This kind of obviously relates into estate planning too, but just also in the nature that even perhaps the way something is titled may not be sufficient either, or somebody thinks something's written into, say, for example, a trust or a will, and there's issues with that in terms of, is the will even valid? Has the trust even been funded? Those sorts of situations where people may think it's titled a certain way and therefore it's going to be an asset or a non-asset. So kind of, I guess, discussing also the variables outside of titling that may come up and affect an asset or a debt going into probate or not.
Yeah, I mean, where do I want to start with the one? So you got me. That was a good one, but wording it correctly.
Yeah.
Um, Obviously, yes, we start with titling. So we see it often. Well, I've got my beneficiary set up. I've put so and so on my deed. Well, those things that land us back in probate. Well, what if so and so has passed away and you didn't update anything? There's potentially language. Again, that one's fairly fact specific. So it's not just if you have somebody who's passed away, it's automatically incorrect.
Mm.
But there's a good chance, and it's worth it to at least get it checked over to make sure. Because if that correct little language isn't in there, yeah, what you thought was a correct asset and correctly titled was not correctly titled. What you thought may have been funded to your trust wasn't actually funded to your trust. I see that a lot. Or the big one with a trust is you forgot you had an account with a different bank from years ago that you're just holding X amount of dollars in, or it was an investment account of some sort that you forgot about that has grown exponentially. Life insurance, you forgot that there's no beneficiary. Those are the ones where everything else goes to trust except for that one policy, and that one policy, depending on value, we're in probate court. So it's tricky because you could think you have everything reviewed, but there's a chance that you don't, and that's why you'll probably hear me continue to talk about a trust. But a trust significantly reduces those risks. So if we have a deed where we've put somebody on it, rather than putting that somebody on the deed specifically, I like to put the trust on it. And then the trust says this property goes here. And then it says if that person isn't around when this property transfers, this is what should happen. So the trust is going to cover all of those A, B, C, D's, and we don't have to change the deed a million times because so
Mm-hmm.
and so made us mad and now we're taking them off. But oh, now we're good again. Got to add them back on. Then we're just using the trust to update as you go. And it's a little less ambiguous
Mm-hmm.
because the trust is going to cover all of those backup plans. What happens if my beneficiary, when they're supposed to inherit from me, is on government benefits and receiving government benefits? Because if they receive a lump sum of money, we've potentially got an issue. So when we can keep it out of probate, because the probate court isn't going to say, yeah, go ahead, let's use things to help this person on government benefits. That's generally not how it goes. We don't have as much leniency.
Mm-hmm.
But with a trust, the trust has provisions built in generally, depending on how and who drafts your trust. But generally, there's provisions that say if this happens, we have these options and whatever this may look like to protect and allow my beneficiary to inherit minor children. And that's the same concept as what we need to do for a beneficiary receiving government benefits. Because if a minor child receives large lump sums of money while from their parent, they're in probate court. That's governed by probate court with guardianship and conservatorship. And that money has to be accounted for. But when we can keep it in trust, it can be accounted for outside of the court with just as much rules and regulation, just less the court cost and attorney
Yeah.
fees potentially. So there's, pros and cons to everything, but really paying attention to how your beneficiary designations are and if things occur to your beneficiaries is very important. And if you're somebody that doesn't regularly review or like to update or wouldn't think about this kind of stuff, it's worth paying attention to potentially a trust working for your circumstance, because then there's less review and less you have to remember because your trust will have all of that covered automatically. So that's probably the easiest way that things end up in probate is, oh, it's good to go. I set it up years ago.
Yeah.
What'd you set up? Let's check it
Right.
out.
Yeah. So I think I heard kind of, I guess what I would say is two things. One on the estate administration or probate administration side is that like titling is usually reliable, but not foolproof. I guess it's not perfect, but it's
100%.
it's usually a pretty good indicator and great place to start. The second one is obviously from an estate planning perspective. I think it's fairly easy to do, and you see it in real estate because it's not entirely difficult to file a quit claim deed and update that kind of stuff, and it does create a host of titling issues that title companies then have to go back and search through and all that other stuff. So it's almost like from an estate planning perspective, a trust is obviously a more flexible option than trying to do a lot of this other stuff. And I also think like from experience, probably it offers greater control because I did have like a client once who he was just listed on the deed, and then obviously he could have sold it and pocketed all the money as opposed to
100%.
being governed by whatever the trust had, and
Yep.
that he was then therefore responsible for just administering the trust and selling the
Yep.
property as part of trust administration. So
That happens so much. People,
I
I've got
I
my
believe it.
oldest on the deed because they know exactly what to do. And I'm like,
Yeah.
okay, I don't love that. Let's
Right.
talk about that.
Yeah, so I think like well, I think that kind of provides a perfect segue into kind of talking about real estate, because I think that is one of the most misunderstood, because obviously we have like the intersection of several areas of law, contract law, real property law, probate law. I mean, it's just like,
Endless.
the yeah, exactly. So I kind of wanted to talk about, why you think a house kind of becomes the most misunderstood aspect of probate, and also, perhaps maybe one of the I don't know if I want to use the word misused, but like inappropriately handled, I guess, from an estate planning perspective. And generally for most people, it's their largest asset. So it's kind of like we should get this right, but
Yeah.
it seems like often we're doing some funny things. So where do you think that kind of, I guess, confusion comes from, and what can we do specifically around real estate from an estate planning and probate perspective?
Yeah, I think you touched on it. It's fairly simple to draft a deed. And I say fairly lightly because in my world, it's very easy to draft a deed for the most part,
Right.
with pros and cons there. But, to whoever picking up a deed template on the internet, what we see is, these entities that offer templates that aren't necessarily crafted to Michigan law, that aren't necessarily crafted to whatever particular type of deed that they're trying to accomplish. And it's just a template, but they don't know any better. They don't know to review that, or that doesn't trigger the correct law, or this, that, or the other. So it seems like there's this easy, cheaper route to protect your property, when in reality using those templates generally end up with people in the most trouble. Right, wrong, or indifferent, I mean, it's unfortunate because it is presented and marketed as such a good resource. And I wish there were better resources. I've yet to find one that I would feel comfortable using myself. But deeds for me aren't something that are extremely costly, as long as it's normal. There's some things that could get into that, but I'd rather you, even if I need to just, you want me to review it, it's worth checking with an attorney to see, hey, different attorneys are going to say different things if you're giving them
Hmm.
a randomly crafted deed from somewhere. I'd much rather prefer that I draft it, if you're going to have me review it. But if it's, you did a deed 20 years ago, you're coming to see me to do a trust, we're definitely looking at that deed. So a lot of times within that estate planning process, that's where I'm reviewing deeds and making sure everything looks correctly. Because in order for me to move it around or draft a deed to transfer it correctly, we've got to make sure that deed you did checks out. Like you've mentioned, chain of title. If there's any defect in any of the prior deeds, we run into issues. So it's a deed. I think is I don't understand why it's so easily confused. I wish that I did because I think it's something that needs to be reduced in confusion. But I think it just is the concept that, well, it's just a deed.
Hmm.
I can do that. I've seen handwritten notepad deeds. It's not foolproof. It's
Yeah.
it's not. And then again, people don't understand a deed has to be recorded. So yeah, you've got your sticky note deed out there, but you never recorded it. And then that's gone by the time you passed away. So title never transferred anywhere.
Hmm.
Honestly, we see it a lot because recording is a fairly new concept in the last, I mean, it's not new, but the use of recording, like my generation, we record. You're not leaving my office with your original deed. I'm sending it in to be recorded,
Hmm.
and then you'll get the original. But prior to that wasn't common because it didn't need to be recorded as much. So we see a lot who have done estate plans in the past with just a signed deed and never recorded their deed. So I have people coming in on the admin side. My parents did a trust. What do you mean it's not in a trust? And I'm like, I can see a copy because a lot of times they'd copy it and put it with the estate plan. That original is not here. So if you don't have that original, the county doesn't have that original, we're going to probate for just the house over something now seeming so simple that, again, we just record immediately. But back then it wasn't the thing. So we have to deal with that and remedy that of getting deeds recorded. So I think it's, yes, deeds and property broken down are simple by their individual task, but knowing those individual tasks, that's not all common knowledge and it's not all
Hmm.
readily available on your Google search. It doesn't come up and say step by step because deeds are pretty county specific. So not just state of Michigan, but county
Yeah.
county has different this, that, or the other. So you're never going to Google and just get one straight step by step by step. So I think that that's kind of where we get into so many complications is everybody thinks, oh, I can just Google it. I did this, this, and this. I'm good to go. And there's so many ways that we can not be good to go.
Yeah. Yeah. While you were talking about it, it made me think of like reminiscing on sometimes when I was like working with general buyers and sellers and stuff was just that um even just the confusion of like thinking like, well, I pay the mortgage bill, so that means I own it or don't own it. Like
Yeah.
people wouldn't understand that, well, only one partner's on the mortgage. However, that title and deed can be held in people's names. So they would think, well, my boyfriend, fiance, husband, or whatever, uh, the mortgage is in his name. So he's the only one who owns the house and things like that. And I think there's that sort of that confusion too that could possibly come up with like, well, perhaps like I lived on the property or, I was renting it from mom or I was living there while taking care of mom and dad. So I paid the mortgage. So I own it. Right.
Yeah.
Not understanding, because they could have made a backwards deal of like, I took a mortgage out or refinanced it. It's in my name, but title isn't. And
Yep.
I think that's probably another area of confusion is where like debt intersects with this and all these other things, family deals, family dynamics, and really, when it comes to the legal side, that the title is the thing that matters. And so, since we're speaking on debt, I think I want to talk about that as far as real estate because, and then obviously probate as well, because I think sometimes there's things where people will do to obviously bypass probate, but that usually isn't, necessarily bypassed probate, but debt is, at least when it's secured, usually goes with the asset. So I'm wondering if you could talk a little bit about that, in terms of that area with the asset as well as like the debt.
Yeah, so debt in general, well, let me backtrack. I want to say a little bit. You were spot on with the family deals and handshake deals. We see that all the time. Well, I was taking care of mom while she was sick. She told me I get the house. If that's not in writing, that means nothing realistically. I mean,
Mm-hmm.
you can argue that in the probate court, but that's how you end up in those contentious probate battles potentially, because it does not mean outright that you're just going to get that house if there's not
Mm-hmm.
something done on that behalf. So I think that yes, that's a huge thing that we see, and that can go right hand in hand with debts. I mean, if somebody takes out a mortgage on behalf of someone, is it subject to the probate estate? It depends. It depends on, are both names on the debt? Is the decedent's name on the debt? Because if the decedent's name isn't on the debt and it's technically taken out by someone else, that's going to land us in a contentious probate battle of how did we get that debt if
Mm-hmm.
somebody thinks that they're not entitled to pay it, and vice versa. When it comes to debt, what debt does the decedent have? I think that kind of goes back to the beginning of, I think you mentioned, yes, slow down, but also there's some things you can do before you meet with an attorney. And this is, what debts? Where are the expenses coming in from? Is there medical debt? Is there funeral debt? Is there past agreement debt? Is there
Mm-hmm.
land debt? Whatever those debts may be, start collecting that information, collecting assets, those types of things. Because there's not just a yes, all debt is paid by the estate, all debt is forgiven. That's not the case. There's laws that pertain to how debt of a probate estate gets paid. There's priority in which debts get paid. So collecting and knowing about the debt is a huge step, because we need to know, because when we get to the point of paying a probate estate out, we need to know what debts need to be
Mm-hmm.
paid, if there are any, before we can pay out the heirs. And yeah, and heirs may not end up getting paid anything because all the debts have to be paid. It depends on the particular debt, or their debt may be, or I'm sorry, their inheritance may be reduced by debts that have to be paid. But if we don't know the debt, then we're in a real dicey situation. So identifying and qualifying, okay, even if we're not at the point of paying, we know these debts are in what order category of priority, so we know what needs to be paid as we're collecting assets and viewing the estate as a whole.
Mm-hmm. Yeah. Yeah, that makes sense. So,
Yep, we're getting
so I think
close.
we'll move on. We'll go to kind of the estate planning side of things. And I think, what kind of conversation should families be having now if this is something that they're thinking about?
Yeah, absolutely. I think it's hard depending on the circumstance in which you're having the conversation. If it's me, I'm having an estate conversation with people who are inheriting from my estate. I'm saying, hey, actually, if it's people who are in charge or responsible of my estate, I'm saying, hey, these where my documents are. This is the attorney you should go to. This is where I'm keeping things. Here's just kind of a heads up. I have you in some capacity. People who are inheriting, it's up to you if you want to tell. They are not entitled to tell. I recommend not, because if you change it for whatever reason over time, if they think they were entitled at one point, there could be some issues. So if it's, I think your key players that you have designated to do things for your estate are people that you should be having the conversations with. I have it done. This is what I have done. Here's where you find those if something happens. Now, if you're speaking from a standpoint of, hey, mom and dad, I want you to get your estate planning done, the conversation is a little different because everyone's estate plan is their own plan. You can't say,
Right.
I'm dragging you in, you're signing this document. This is exactly what it's going to say. You're in a whole world of trouble at that point. That estate plan is likely not valid. And there's a whole lot of questions surrounding that. So, if you're in that position where you know you're likely going to be the one in charge and you're wondering, have more of a, hey, do you have anything done? Do I need to know where you have documents done? Do I need to know who to work with? And if you do, again, what are kind of those specifics? Do I have a key to this, the code to this safe? Do I have the business card of the attorney I should work with? And if you don't, how come? Is there something I could help you with in getting one set up and helping you down, helping explain it, helping getting you connected? Because you can work with attorneys depending on, again, certain circumstances. If there's ever a reason I felt like I couldn't work with or separate families and it was overwhelming, we wouldn't work with them. But if everything's separate, it's a referral concept. If you want to refer your children or your parents, there's an open conversation about what that looks like. But again, it's, you can't drag them into me, and I'm not going to let them. If
Yeah.
it's something where I'm, questioning, we're very conscious about that because it is something that we can work with families separately, but we cannot blur lines and make it all one big concept either. So I think it's, do what you can to encourage the estate plan, especially if you're in the position of you're going to be in charge, but you also can't force them either. So
Right.
be careful with that, but it's worth those conversations of, can we get something done?
Yeah. Always a tricky place to be, but definitely, I think it's nobody has to disclose everything, but I think there are conversations that are at least worth starting, even at a simple level. Because yeah, I
Absolutely.
always think nothing should be a surprise when somebody dies in a way, and that's,
Right.
by then it's, a little bit problematic if that's the case. So,
Right.
with that said, how can people kind of work with you and, do you do all over Michigan? Do you look at different kind of estates and that kind of thing? Just talk a little bit more about kind of who you can help.
Yeah, so I work with a firm based out of Flint in Genesee County, Clint Perryman PC. So I'm based there, but I also have the ability to meet with clients in person in the Lansing area. So between those two, I cover a big chunk of mid Michigan at least. But I'm also available to meet with clients remotely. I've worked with clients all over the state, whether estate planning and or estate administration or probate. So there's really no bounds. It just depends on kind of what we're doing and what that looks like. But we can meet virtually and discuss on the phone some particular circumstances and get things set up. So as long as it's the state of Michigan where I'm licensed, I can attempt at least to help. And if not, I've likely got contacts where I could get you directed to, because it's worth checking into. I can do pretty much anything within the estate planning world. Estate administration, I don't typically deal with contested estates, but if it's uncontested and going to be simple or informal probate, that's right up my alley. But I've got connections I can connect you with for contested estates, or guardianship, conservatorship, some of those more formal court proceedings. I don't typically jump in on, but have connections I can absolutely set you up with. So I'm pretty flexible in ways we can meet. Whatever works for my clients, I can make happen.
All right, fantastic. I
Yeah.
appreciate you taking the time.